Do you understand? At that point, we're going to go forward, but I'm ordering you now as a condition of your bond not to drive. If I find that you drive and I will give a rat's behind what you're doing, I will have a contempt hearing. You'll be facing up to 6 months in jail and or a $500 fine every time you drive. Do you understand? I don't care what your excuse is. I don't care where you're going. I don't care if Jesus needs to ride to church. You drive, holy moly. It's Jason Johnson, his lawyer. So when Mr. Johnson gets here, I'd like to see if he has insurance. Otherwise, there's no driving affidavit. Yeah, hold on it. Mr. Cormier? Mr. Cormier, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Oh my goodness. He's charged with 2 FSRAs. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On September 7th, 2024, officers were dispatched to an FSRA call at 1220 Brickmore Road in Harris County, Texas. Officers flagged down by a witness who pointed the officers in the direction of the defendant. The officers made contact with the defendant, who was trying to take items out of the trunk of his vehicle. The defendant stated that 2 cars hit him, that he turned off into a private drive due to a busy street, that he lost control and went into a ditch, and that the vehicle belonged to his mother. The defendant stated he was not drinking. The defendant later stated he had one 16-ounce Bud Light, but that he was not drunk and he was good. Standard field sobriety tests were administered. HGN 4 out of 6, walk and turn 2 out of 8, and 1 leg stand 3 out of 4. Defendant was read DIC and consented to breath. Results were .148 and .131. Defendant was identified with Texas driver's license. And officers made contact with the 3rd complainant. The complainant stated the defendant's vehicle came from a side street and the defendant struck his vehicle and the complainant complained of wrist pain. The damage to the 3rd complainant's vehicle was approximately $20,000. Officers made contact with another complainant. The 2nd complainant stated the defendant's vehicle took a U-turn, struck his vehicle, and the complainant complained of pelvic pain and head pain. The motor vehicle damage to this complainant's vehicle was approximately $30,000. The 3rd complainant, the 1st complainant's passenger, complained of rib pain.
See if he has any prior DWIs.
He has no prior DWIs, Your Honor.
Mr. Cormier, I'm going to find that there's probable cause to go forward with your case. Do you have a Texas driver license? Oh my God. Tell me you have liability insurance.
Our insurance policy just went up in August last month.
Do you have? If I send you now for a drug test, what's going to show up? I'm sending you now for a drug test, and you must come right back. If you do not come back, your bonds now are, I'm in shock that your bonds are only $3,000 on your these are 2nd-degree felonies, right?
These are
This is a multi-complainant crash scenario, which is exactly what prosecutors look for in serious DWI or intoxication assault cases. You've got inconsistent driver statements, a partial admission of drinking, failed field sobriety tests, and then the breath results in 0, which are extremely significant. To put that in perspective, is the legal limit. These numbers are not just over the limit. They are in the range where coordination, judgment, and reaction time are severely impaired. And now multiple injury complaints turn this from a simple DWI into a potential felony level case exposure.
five years.
Say it again?
Yeah, it's one of those hybrid felonies that's got a punch range of up to 5 years. So I'm not quite saying.
I'm sending you now for a drug test. You must come right back, Mr. Cormier. If you do not come back, I'm going to set your bond at around 10 times what your felony bonds are at. Do you understand? At that point, we're going to go forward. But I'm ordering you now as a condition of your bond not to drive. If I find that you drive and I will give a rat's behind what you're doing, I will have a contempt hearing. You'll be facing up to 6 months in jail and or a $500 fine every time you drive. Do you understand? I don't care what your excuse is. I don't care where you're going. I don't care if Jesus needs to ride to church. You drive, holy moly, I'm going to light you up like you've never seen before. I want him to go take a drug test right now, and then we'll have him come right back. I'm going to have you sign a reset. Hold on. Before he leaves, I'm going to have him sign this affidavit so I can hold his ass in contempt if he tries to drive. All right, I'm going to have you come up here, swear testify, not to drive. I'm going to have you sign a reset and go take a drug test. So are you, this is Mr. Cormier. This is the one where that we have at least, is it 3 people that were pretty badly injured, right? At least 2.
Yes, sir.
Okay, Mr. Cormier, I don't want you out in the middle of the night. I'm now going to put an ankle monitor on you so that I know that you're not out in the middle of the night. On one ankle, you're going to get a monitor so I know you're not, so I know that you're not consuming alcohol. On the other one, you're getting a GPS monitor, and I'm giving you a curfew of 9 p.m. to 6 a.m. If I find you out, I'm going to lock you up, and I'm going to make your bond so very high, it's ridiculous. Do you understand? I will do everything in my power to protect every person of Harris County, and if that means locking you up at 100,000, I'll do it in a heartbeat. Do you understand? Do you work? When is the last time you've had a job? What were you doing?
Solar company.
Why did you lose your job?
Just HR problems. Problems with HR. About my performance and crime.
Okay,
This is where the court moves from punishment to surveillance. An ankle monitor for alcohol and movement restrictions is a form of pretrial control designed to prevent both reoffending and evidence tampering. In serious intoxication cases involving injuries, courts often treat defendants as ongoing risks to the public. But here's the tension. At what point does monitoring become prevention? And at what point does it start feeling like punishment before conviction? That line is exactly what modern courts constantly wrestle with.
it's time for you to get another job.
So,
And now also making that a condition of your bond. I want to know that you're working, not out doing nothing. Too much time on your hands, you become self-destructive, and I'm not going to have it. So I'll appoint your lawyer today, Mr. Cormier, but I'm bringing you back in 2 weeks, and I want to know what you've done to get a job. If you've done nothing, it's just not going to go well between you and I. So take a hint. I'll have you sign, or he's already signed a reset with you. So for now, I'm going to have you sign your conditions with Rachel. After that, I'm going to have you take a seat in the jury box while I find your lawyer. All right.